So again, if you have a question, for those of you not in the room with us, send it to my email address. And we're going to do 3 50-minute sessions. We'll have breaks in between. I'll give everybody notice when we're going to get started. We will try to start right on time. So when I ask you to take your seats, if you would do so, I would appreciate it. And I will turn it over to our first presenter, J.E. White, for our first session. Thank you.
Good afternoon. I'm J.E. White, and I'm going to start the seminar today. I want to thank everybody, thank Anita for letting us have this probate seminar, and I'm glad we have a lot of registrants. I think we have a total of 425 right now on the internet, and we have a full house here in Charleston. So we appreciate you coming out to listen to us talk about probate, and we must be getting near or within 5 months of a reporting period or something, because this is a lot of interest in a fascinating topic that Chris and Josh and I deal with on a daily basis. So really, here's where I want to start. So estate planning, or a couple goes to their estate planning lawyer's office to talk about doing their will. And on the way home, they have a conversation in the car, and basically it goes something like this. The husband says, you know, look, if something happens to me, I don't have a problem with you remarrying. You're young, you're attractive, there's no reason to go through life without a spouse, and so you can remarry. And matter of fact, I don't even have a problem with you living in our house. I don't have a problem with him using my fishing equipment, guns, tools, anything like that. But one thing would really bother me. And she said, well, honey, what's that? And he said, I don't want him using my golf clubs. And she said, well, you don't have to worry about that. He's left-handed. So a little lighthearted humor to start out. And so for those on the internet, I will just tell you that we got a standing ovation on that joke here in Charleston. But in all seriousness, Angie mentioned, if you have questions, you can ask them at any time. You can stop me and we can get back on track. I've kind of got a big topic. I'm going to do an overview of the probate system, kind of some bits and pieces of different components that we deal with more frequently than some of the more arcane parts or statutes that we occasionally have to dive into. And so my focus today is going to be on the beginning, the start of the probate process. But we're going to kind of go all the way through, kind of like a tour de probate with very topical in the beginning, and then we'll dive a little deeper. And I'm going to focus on Chapter 41, which is the will section of the code, but really 41-5, which is the section that deals with the probate, production, and recordation of wills. And then Chapter 42 is descent and distribution. In the event we don't have a will, we're going to take a peek at that section. And then Chapter 44 is the administration of wills and trusts, or estates and trusts. So that's where we're going to go. I'm not really going to do any deep dive. So let's start with the first question is, what is probate? Before I came up here, I turned this in a week or two ago, and for my purposes today, what I'm talking about is when a decedent passes away, the handling of their estate from beginning to end. That's kind of what I view as probate. But before I came up here, I Googled it, just like my kids. Well, let's Google it and see what it says. So I Googled probate definition, and the actual definition that came out first was the official proving of a will. So to me, that's right in the very beginning, and that's kind of where we start. And in West Virginia, the question is, where do we start? We have probate jurisdiction. And so jurisdiction for probate generally lies in the county commission in West Virginia, and that's pursuant to Article 9, Section 11 of the Constitution, the West Virginia Constitution, and then Chapter 713 of the West Virginia Code. Those are the jurisdiction, powers, and duties of the county commission. Okay, county commissions, generally, they have a lot of things going on, and probate is just one. And to a lot of them, I believe it's not a major thing. And it may not be for the bulk of people out there. They've got more important things to do. But the code does give them this jurisdiction to deal with the probate and administration of wills and estates. Some other jurisdictional things, and really they pertain to matters outside of probate or that may happen in probate. It's kind of going to be where I end this talk, but 4137 of the West Virginia Code talks about courts of equity can construe wills. So if you have a question on a will, you may get some jurisdiction there up at the circuit court level. And then that is generally tied with the Uniform Declaratory Judgments Act, which is 55-13 of the code. And basically, that gives you some authority to get into circuit court. And then 5122 is really circuit court jurisdiction. And so those are other places to look at if you have a problem. But generally, we're talking about level at the county commission. And then you always, if you have an issue at the end of your probate or appeal or a will contest or something like that, you're always going to go up to circuit court. So where do we probate? So kind of to begin, and I have some topics first, and then we'll do a deeper dive into the probate section. But so we have a death, and we're going to say, well, where do we need to probate that? West Virginia Code 4154 is where you need to look. And the first place they're going to say the proper place to probate is where you have a house. The code actually says mansion house. That's a little antiquated, and I'm not sure what that means, but it's where you have a house or where you have a known place of residence. That covers most folks, okay? But if you don't have a mansion house or a known place of residence, B will say, well, where you have any real estate devised thereby. So you can not have a house, not have a place of residence, but you have real property in Work County, you can probate in Work County. Then the next one down, if you don't have any of those, the county where you died, or the county where you have any property, even if it's personal property. So that's your next section to probate. And then the last one is if you died out of state, you can admit to probate in any county in this state where the property is devised or bequeathed thereby. Now, Chris is going to talk a lot more in a little bit about ancillary administration and how to accomplish that. And so that's really all I'm going to talk about with respect to that. And so my next topical slide is what type of probate systems for proof and allowance claims we have in West Virginia. So you'll hear a lot of times that we have two probate systems, really. We have fiduciary commissioner counties, and that's the bulk of the counties. We have fiduciary supervisor counties, and they're governed by different code sections. And sometimes when you get into these things, somebody might be mixing the two. So you have to be careful and make sure what county you're in and which system they follow. But at the end of the day, the process is similar, and you can handle all that under those code sections. Josh is going to talk much more about creditors and claims, and so I'm going to leave the bulk of that for him to discuss. But really, in my mind, we have 55 different probate systems. I mean, literally, every county does something different. There's always a little tweak here or there. And so if you're dealing with a county that you're not typically involved in, we always say, just pick up the phone, call them and say, how do we handle this or that? So you need to know the system that you're operating under. And at last count, my last count anyway, and I didn't look it up before I came today, I think there are 9. I don't know if there's any more fiduciary supervisor counties in West Virginia, but there are at least 9. So who's the person in charge of the estate, or who's going to handle this estate? We sometimes call them the personal representative. We may give them names, executor, executrix, if they're named in a will, administrator, administratrix, if they're not in a will. But this is the person that's kind of in charge, puts the fiduciary hat on their head and says, I'm handling this estate. So they're the peoples that will handle the estate. And so let's go back a minute to intestate. Do we have a will or not? And so if we don't, in this slide, we don't have a will. So we've got to figure out who's to be appointed as administrator or administratrix of this estate. So we're going to look to 4414 of the code, and it's going to say, well, look, and I've got a misspelling right here, to distributees. And so I hate that, but there it is. So if you do have the PowerPoint, add an E for me. Intestate versus intestate, to distributees who apply. The pecking order, so to speak, is the surviving spouse. She or he will get priority to become the administrator or administratrix of the estate. If you don't have a surviving spouse, or if the surviving spouse doesn't want to do it, then you have to look downstream or look to others. And the clerk, the clerk can pick who they deem fit. Sometimes this is a little bit of an issue. You may have 3 children. 2 of them say they want to do it. So now we've got a predicament. Some counties will just say, well, if we fall it in here, if son goes to the courthouse, mom, dad doesn't want to do it, then we'll appoint him. Other counties may say, we're not going to appoint him unless we get the other 2, if we have 3 children, the other 2 to sign off and say he can do it. But then after 30 days, all that goes away. So then it becomes race to the courthouse. So whoever after 30 days gets there and raises their hand and says, hey, I want to probate, or I want to handle this estate, even a creditor, they can qualify as administrator or administratrix of an estate. And so every estate needs one of these folks. Every estate has to have a personal representative. And every estate ultimately is going to have, it will have beneficiaries or heirs, who the property is going to. So we've got to have those things. So that leads me to who's entitled to the assets. And so in intestacy, we have a provision in the code. We have a whole chapter on descent and distribution. And this is what I like to call the legislative estate plan. And so this is kind of what our legislature has put in the code that says, if we don't have a will, who gets the property? And so somebody decided this is the way we want it to go. And you look first to surviving spouse. And the way it works is, and the code section's there on your PowerPoint, the surviving spouse, it gets the entire estate, gets everything if there's no descendant of the decedent. No children or downstream descendant. All of the decedent's surviving descendants are also descendants of their surviving spouse. So husband and wife has 3 kids and they're all together. Maybe first marriage all together, maybe not, but that's where we're at all together. The surviving spouse gets everything. Okay? If that's not the case, let's say in my example of husband and wife, they had 3 kids together, but she survives and she had another child outside of that marriage, then she gets 3/5. And so the children of the decedent are going to get the other 2/5. And then if that's not the case, if he, the decedent in my example that passed away, had another child before that marriage, then it's 50. The surviving spouse gets 50%. And then once you figure out what the surviving spouse gets, then you look to, well, where does the rest of it go? And so the next section in the code basically says, okay, to the decedent's descendants by representation. And that means children or downstream. So we're going to look, did the decedent have children or anybody, if child's deceased, downstream further. If not, then we have to go somewhere else. But to the decedent's descendants by representation, tricky little part on by representation, you really have to look at a following code section to figure out what that means. It comes up a lot when we have somebody that's passed away and we have some similar level, but they have already passed away before the decedent, and whether or not it's per stirpes or per capita. And I think the code section on that's 4213D, and so always pay attention to that. But if there's no surviving descendant, so we have nobody downstream that survived this person, then we have to look upstream. And so we go up to the parents. So if you have parents surviving, we're going to let them have everything. If only one survives, they're going to get everything. But if they don't, then we're going to parents, and then we're going to come out to, okay, the parents, and then did they have any other children? Okay, any other people. So really we're looking out to siblings of the decedent or siblings that are predeceased that leave, children under them. And so then they'll figure out that you figure that out. And then if you don't have any of that, if you get in one of those situations where you don't have any of those, then we have to go up to grandparents. And then we come out, and it can really become very complicated as to who takes in that scenario. So the next slide is going to talk about testacy. So now we have a will, and this is always much cleaner, it seems to me, because we get to pick who we want to take our assets, and you get to pick who you want to handle your estate, who the executor is. You pick your beneficiaries. You can waive bond. You can, you have your specific bequests. I like to tell people, look, if you have something, whether it be valuable or not, but you want to make sure somebody gets something, let's put it in the will and make it happen. Doesn't always happen, and I don't want 5 pages of this shirt goes here and this ring here and the Bible here. But if there's something that's really important, let's get it in there. Sometimes you'll see people put provisions in wills that say, I might leave a memorandum, and I want that to be, followed by the heirs. It's not really legally binding, but it is something that says, hey, he thought about it or she thought about it, and this is what they wanted. So we have a will, and then we go on. So now I'm going to get a little deeper on, we have somebody that's passed away. Okay, you get these calls all the time. Somebody's passed away, and they'll say, what do I do? So really what you tell them is you need to lock the doors and call security. Because how many times have we been called that says, Dad's not even buried and sister's in the house and they're carrying all kinds of stuff out of the house. What do we do? Well, it becomes a difficult situation. I don't like, nor probably Chris or Josh, like dealing with tangible personal property things. Matter of fact, I tell people a lot of times I don't want to get involved in the tangible property dispute because, frankly, a lot of times they're just not worth it. And you tell people that, but if they still want you to fight for the family Bible, then that's what you do. But you do have a code provision that says, an executor or an administrator doesn't have any powers until they qualify. And that may not be until 2 weeks. A week is probably the earliest, 2 weeks after, the death. And so you don't really have any powers. But there is a code provision, 4411, that basically says you can provide for the burial, you can pay reasonable funeral expenses, and you can prevent waste. And so I guess my argument would be, I'm not letting you, sister, take this out because I am the nominated executor and you're wasting assets of the estate by removing them from the house. But anyway, what you really want to do, you've got to locate the will. You want to probate the original will. So you've got to locate the original will and then, look at it and make sure who's what and then where you go from there. So now we get into the technicalities of probating that will. And so the code gives you, and normally this doesn't come into play, but there is a law out there that says, and it's 4151, and it does say a person having custody of a will shall, within 30 days, park it with the clerk or get it to the named executor. Okay? And and then they have to probate it within a reasonable time. And so that's really what this code section says. Interestingly enough, though, the last sentence in this, any person who shall, without reasonable clause, neglect so to deliver a will shall be guilty of a misdemeanor, and on conviction be punished by a fine not exceeding $200, and shall in addition be liable to any person interested in such will for damages caused by neglect. Okay? Has anyone ever seen anybody convicted on that crime? No. Okay. It's a resounding no in Charleston. And I've done this type of work for 25, 26 years. I've never seen that happen either. Never really been involved in anything like that. But there it is. So now we have the probate procedure. So when you actually go to probate your will, we have a couple different ways to accomplish it. We can do what's called probate in solemn form, and that's laid forth in that code provision there, 4155. The gist of it is, I'm not going to dive deep into that. You got to file a petition, you got to set forth a lot of elements, and then you've got to serve everybody that's interested, and then you'll have a hearing. It's a complicated process. It draws it out. Most of the estates I deal with, a great majority of the time, I have in my notes here, I jotted down, I would venture to say 95% of the time use that ex parte. I'd probably even go up even higher, like 99. I mean, rarely do you get into a probate in solemn form situation. And so ex parte is the way to go. 41.510, you don't need a petition. They take the will. It generally has a self-proving affidavit, and you go probate that, and you become the personal representative for that estate. One important note is when you do that and you probate that will, it is a public record, okay? And so in today's times, you hear a lot about avoiding probate and different things you can do and move things to this or do these transferable death deeds or do these revocable trusts and all that. Those, as we get to the form component of this talk, I'll show you what it means, but there is privacy. There is a privacy component to this. And so, but the will's out there. So whatever you put in the will, anybody forevermore will be able to go to the courthouse and look it up and see what exactly you did. So the general steps for qualification, you need a death certificate, okay? But you check with your counties. I mean, there has been a couple of situations in the past where you probated without a death certificate, but it's rare. You might get a funeral home to sign off on something if something really needs to happen, and some counties won't accept that. So you need the death certificate. What I like to tell people you need is, look, you need the original will, you need the death certificate, you need your checkbook, okay? And then you need names and addresses of the beneficiaries in the will or the heirs at law. And if you don't have all that, maybe you say, well, it's unknown to me at this time, you go ahead and qualify, but at some point you've got to supply that affidavit as to that. And then you look at the will to see whether a bond is needed or not. Now, if we have a will, most wills I see waive bond. But if you're in the intestate situation without a will, there is no bond waiver. So therefore, you have to arrange with an insurance company, a bonds person, to go your bond, and that has to be done really at the time or in advance of you going to qualify as the personal representative. Oh, I thought that was moving on down. So I think I've covered all that. And so then you take the oath, and so you say, okay, I'm going to do this. I'm going to administer this estate best of my ability, and you take the oath. And one of the things that you do check, this next slide, is just how to qualify. Call them if you're in a county you're unfamiliar with. Call and find out exactly what the process is. Some of them may let you send the documents in advance, and they'll have it all ready, so it eliminates the time you're there. Some of them won't let you do that. Some of them are by appointment only. Some of them you got to go sit and stand in line. So that's just county by county. So here's a letter of administration. This is just a sample letter of administration. This one actually is from Raleigh County. Fiduciary Supervisor County does hereby certify that J.E. on the blank day of blank was appointed executor of this estate, duly qualified, took oath, bond in the amount of 0. So that would have been a will that waived bond. This is in full force and effect. And so you get all your powers then. So this is the document. This is the document, the authority document for the personal representative. This enables you to basically stand in their shoes and do virtually anything they could have done. Excuse me. Maybe still currently today. I mean, I call it. Anybody know any other names for what this has been called?
Probate order.
Probate order. Okay, yeah. So probate order. I've seen them called letters testamentary. Used to be like order confirming executor, but it's the document that says this person is in charge of that estate. So you'll walk out of there. You'll walk out of the probate office that day with that document, and you probably need 5 of them or maybe 10, depending on how many assets you think you're going to have to go and deal with. Most folks, banks and so forth, want to see an original and, the race and stuff. So you need several of those. You can always get more. So you might start with 5 and then wait and get more later. But that starts it. So now you have the authority to start taking care of and handling this estate. So one of the things we like to say next is, what do you do next? And so first, get a tax number. Okay, so we like to get a tax number right off the bat. And then next, open up a bank account. And we like to tell people, look, open up a bank account, J.E. as executor of blank estate, and just have it right there. So you're doing everything inside of this bank account. Do not commingle these. Do not put assets of the estate into your own name. It causes heartburn and litigation and things like that. So open a bank account, keep it all separate so it can easily be traced and tracked. And so, and that's the place where you put in when you go to the bank and you present the order and you get $50,000, dump it into the estate account. And then that's in there. And then you see, you write checks, you might get a dividend or interest, or you might sell a car, and everything deal right there in that bank account, and really keep tabs on that. Your other obligations, you got to collect, marshal, protect the assets. So you want to collect all these assets. You're going to pay debts and claims, and then at the end of the day, you're going to push these assets out to the proper beneficiaries. Many other items to handle. Lots of things creep up. Let's play a quick version of Family Feud here. What are some? I've jotted down 1, 2, 3, 4, 5, 6, 7, 8 things. Anybody want to take a shot at one other thing that we need to handle?
Dividing the furniture.
Got it. Anybody else? No other shots? Well, things that you right off the bat, and what I kind of jotted down this morning was, you cancel credit cards, start monitoring the mail, deal with utilities, deal with taxes, deal with insurance, cancel subscriptions, cancel Social Security, and deal with creditors. And so those are just some of the items that we're going to deal with. So, yes, sir.
I got a real quick question about that. A lot of these things now are done online or through an app or something like that. And if they don't have the passwords available, if they didn't write the passwords down, or they just remember them, how do you go about, what's the best procedure for, say, dealing with the online brokerage account? Yeah,
online accounts. We do have and I'll get the name wrong, but we do have now the Uniform Fiduciary Digital Asset Act or something like that. And so you have to deal with, and we generally add a provision in our wills and in our power of attorneys that tell you what all authority you have. And so, because you could get locked out. So one of the things we tell people is to get a password manager, have them all there, and know it. But if you don't, then you're just dealing with, the bank that you're online with, and trying to get them to accept your order and trying to find out information and so forth.
2 years ago, our legislature passed the revised Uniform Fiduciary Access to Digital Assets Act,
Okay.
There you go.
affectionately called RUFADA. Okay. RUFADA clarifies that digital assets essentially can be accessed by a fiduciary, including an executor or administrator, a guardian, or an agent under power of attorney. For the most assets you're dealing with, like a bank account or a brokerage account, it's property, it's an asset. The executor or administrator duly appointed will have access to that. Now, that doesn't mean you get the password. You get the asset. The TD America Trade account, you can access that, get it retitled, executor can sell the securities, raise the fund.
Thank
But
you.
if you have questions on that, it's RUFADA.
Okay.
Perfect. Yeah, so the next thing you do, and one of the things that you generally walk out of the probate office with, not only your order, but you have that little booklet. And that little booklet is, and they'll tell you, look, you need to fill these forms out and get them back within 90 days. And it's going to contain the appraisement of the estate, which we generally call Form 6.01, and the non-probate inventory of the estate, which we call Form 6.02. And then I have their 90 days from qualification. You can usually get an extension if you need an extension. A lot of people get it done really quickly. A lot of people, with complicated estates and closely held business interests, you may have a hard time getting it done within 90 days. But really what we're talking about are probate assets, and we're talking about in the decedent's name. So we're looking at things that are in their name only, okay? And so the different types of that are tangible personal property, furniture, furnishings, clothing, jewelry, those types of things, real estate that's in their name only, stocks, bonds, securities, bank accounts, CDs, notes, business interests, okay? And so those are your typical probate assets that you would see, and those will go on the Form 6.01, which we're going to look at here in a second. And then your non-probate assets that we deal with frequently are jointly held real property. Now, jointly held property and transfer on death property is going to go in the 601 for real estate purposes, but it is a non-probate asset. So jointly held property, jointly owned bank accounts, life insurance, it's a contract, retirement plans, annuities, assets moved to revocable trust. So if you've already moved everything to the revocable trust, you're going to be here instead of there. And so this is the form. I'm not really going to go through that form, but one thing important on this form, this is the Form 6.01, is this is a public record. So again, the will's a public record and the 601's a public record. An important component that you need to watch for is Part 1, Box H. That's the real estate provision. If we have real estate in another county or an oil and gas interest in another county, we want to list those counties here, and then you as the executor or personal representative want to get a duly certified copy of this at some point and file it in that other county. And I'm going to skip the bottom part. It's just a recapitulation, really, of everything that's going to be forthcoming here. We'll deal with the real estate component in a minute. But Part 4, Schedule A, is where you start diving into that form, and Part A deals with real estate. And so there is a debate or a question as to whether or not real estate is a probate asset or a non-probate asset, just in its own right. But I generally take the position that if it's in your own name, it's under the will or under intestacy, and so we need to report it here. And so you list your real estate here that's in your own name, your oil and gas interest, because oil and gas in West Virginia is real property interest. Tangible personal property. This is where you'll list things like your clothing, furniture, guns, any type stamp, baseball card, coin collections, jewelry, vehicles, boats, those types of assets flow into there. You just fill it out and drop down and move your total to the front recapitulation page. The bottom one, Schedule C, is bonds, and that's just like a corporate bond of any type. The top of the next page, Schedule D, it's used a lot. That's your 100 shares of Disney, your 100 shares of Starbucks, Apple, 100 shares of your own closely held business interest. Schedule E is cash, cash and other assets, savings account, checking accounts, certificate of deposit, and so forth. This is just a catch-all down here at the bottom. If they don't fit neatly somewhere else, you can put it in Schedule F. Then you list in Part 5 your beneficiaries. So beneficiaries are heirs. So if you have a will, you're going to list your beneficiaries under the will there. If you have intestacy, you're going to list your heirs. You fill that out and you file it as soon as you can, but to get the creditor period running. But this is the inventory of non-probate real property. I mentioned a minute ago that real property, even if it's non-probate, you still report it on the 601, because in West Virginia, you can really pass real property 3 ways, by intestacy, by deed, or by will. And so if you move it to the 602, which is not recorded, there's no way to really track title to real property. And so we're tracking title here, inventory of non-probate real property. So this is your house jointly held with your spouse, or a family farm jointly held in some way, shape, or form. And you answer those 5 little questions, the type of transfer, and it's just going to be house with joint with right of survivorship. Name the person who has an interest in that as a joint tenant. B, surviving spouse. C, relationship, surviving spouse. Market value, $200,000. Description of the real estate. And you just put in there description of real estate. Take your time and do that the best you can. I mean, track that is good. You see everything, but I like to pull the tax tickets, and then I'll use the tax ticket description. I'll use the county, the district, the tax ticket description, the map parcel number, and then I'll also say more commonly known as 11 Bethmont Drive. It doesn't take that much to put that information in there. So then I'm running a little bit short on time, so I was going to go back to the recapitulation, but really you're just going back and filling those items out. So the next slide I'm going to deal with is the beginning of the 602. Again, this is not a public record. It is filed with the clerk. Generally, you file them at the same time. You go over there, but this doesn't get recorded, and so this has a little bit of a privacy component in it. And these questions down here, the ones we see often, are going to be like number 3. Did the decedent make a transfer in trust which passed to others upon his death? Yes. Revocable trust. And then you list it and you answer those questions and the value of that revocable trust at the time of death. 4, did the decedent own any stocks, bonds, bank accounts, CDs, or any other personal property? Yes, there's usually joint accounts there. And if you're in this space much, that is probably the most litigious aspect of wills, trusts, and estate administration, all that, are these jointly held accounts of whatever nature. And then life insurance policies, number 5, yes, there's a policy, annuities, your retirement plans and all that. So that's the gist of the 602, and that's where you kind of do the same thing with those A, B, C, D, E questions, and you file this, and it does not become a public record. So I'm going to go back to the will of public record, the 601's a public record, and so if I have $1 million and I'm going to leave it to my wife, and it's in my name, my will says I leave everything to my wife, and then I file the 601 following up on that, and it says, well, J.E. had $1 million. So everybody knows what I had, where it went, okay? And so some people don't want people to know what they have. And so one of the mechanisms that we use a lot is a pour-over will with a revocable trust. And so before I die, A lot of times, I even see a lot of times it's set up and then the assets aren't moved, which you defeated the purpose. You might pour it over to the revocable trust, but if it's still in my name at the time I die, then the million is still on the 601 and not over here on the 602. So a lot of times what you'll do then is just do a will that says, I name Chris as executor of my estate. I give everything I have to the JE Revocable Trust. And then I go, in my example, take that million and move it to the trust. And it's moving money from right pocket to left pocket. JE's still in control. JE's trustee of his own revocable trust. And so there it is. And now, for recording purposes, the will doesn't show where it went. It just says it goes to JE's trust. JE's trust is not out there, public record anywhere. And then on the 602, if I can go back, I'm up here in this question. Did the decedent transfer in trust that passed to others upon his death? Yes, $1 million. So now nobody knows anything. And so that's a real benefit for a lot of folks. But for some reason or another, in some instances, we hear, I guess everybody, we hear that the number has gotten out somehow. So we'll leave that for another day. Josh is going to pick up on this, really, creditors. But, really, all I want to say is the 601 is published upon filing. So when you return that, and then I think the law will say within 30 days of my returning that 601 to the clerk's office, they have to publish it. And they're going to publish it for 2 weeks. And the publication, you've all seen them, it's out there. I have before me the appraisement of the estate of, and any creditors can come forward and file claims. Creditors can come forward first. They don't have to wait for that. But that's when it is. It gives them a 60-day period from the date of first publication. And then that's really, I'll let Josh finish that topic. Okay. So we've talked, kind of ran the gamut there of where we are, possible things that come up in this type of practice, a will contest. Okay, so we get in these things, somebody's unhappy, mom, dad, left a will, didn't leave something to a brother or a sister or whatever, or for whatever reason. Generally, if there are, 3 kids and 2 of them get it all, somebody's unhappy. And so they can bring a will contest. There is a statute of limitations in West Virginia when you can do that. Generally, I will say it's 6 months from the day you become qualified, but really there's another little, it's the confirmation of qualification that your true statute of limitation runs against. Difficult family relations, oh my gosh. I mean, anybody that's dealing in this stuff, we're holding hands and wiping tears and things all the time. We could all tell stories ad nauseum until, on the relations, and people really get emotional here. I mean, it's emotional, and you have to constantly be talking to them about the economics of fighting versus, and the emotional roller coaster you'll be on versus just resolving it in some way, shape, or form. Construction of a will, as I mentioned earlier, sometimes there's just poorly written wills. Comes up a lot with holographic wills, comes up some with LegalZoom wills, comes up some with a lawyer drafting his own will. You're like, what are they talking about? This is a difficult, ambiguous provision, and we don't know what to do with it. And so if you're advising the personal representative, or you are the personal representative, you have to say, look, I'm not doing anything with this until a court tells me what to do. And you get everybody up in front of the court, and you get that court order that says, this is the way it's going to be. Because there can be great differences in money on these types of provisions. And then, I have here surviving spouse files a claim for elective share. You hear all kinds of things on this topic. You can't technically disinherit a surviving spouse. That's probably true, but it can be done. But they have rights. Okay, so when I say it can be done, what I'm talking about is you can draft a will that cuts the surviving spouse out. There's no prohibition on that. You can draft a will / trust that cuts them out. Okay. But you certainly don't want to do that without a letter in your file saying, I've advised you of this, this, and this, and this, to kind of cover your butt, going back, because somebody's going to come in and file something. But in West Virginia, they have a right to file a claim against it. So if you have that situation where you cut a spouse out, you're not necessarily cutting them out until like 9 months after death, okay? Because they have a right to file a claim against the estate. And that right originates, and there's a code provision on it, I think it's 42-3, but they have to take affirmative action to do this. And if they don't do it, too bad. If they die a week later, too bad, they're out. So, now they can be incompetent, a power of attorney and a guardian conservator can file for them, but that's kind of where we are there. It's not automatic that they get that. Okay. 2 minutes. Okay. This is my favorite topic. And today's, this is not really pertinent to today, but it is something executors do. I love to talk about taxes. So taxes here, one of the things a personal representative has to do is make sure they file the final income tax returns for the person, both federal and state. File the estate income tax returns. That's going to be like your 1041. There's one little note there, can elect a fiscal year in an estate. You can elect a fiscal year instead of all of us in this room are operating on a calendar year. This is a component I really like to talk about, but this is an estate tax return. Within 9 months of death, you have an obligation to file a return within 9 months of death. You can file an extension, get another 6 months. The 2020 exemption amount is $11.558 million.
J.E., I think you got a typo there. The exemption is $11,580,000.
Okay, well, there you go.
Josh and I both just confirmed.
580, right. So that exemption is pretty big, but it is set to sunset. It is increasing every year. Like last year, it was like 11.4. I mean, it goes up a little bit, indexed for inflation. But at the end of 2025, it cuts back. There's a whole day's talk on that. And then one question that comes up is, should you elect portability? That's been around since 2011, and it gives the executor the ability to file a return to transfer any exemption amount over to the surviving spouse. That's something new. One last slide, compensation comes up a lot. Yes, there is compensation for an executor handling an estate. There's a code section right on it. This is kind of the analysis. So if you had $1 million estate, you get 5,000 on the first 100,000. You'd get 12 on the next, 12 on the next, 2 or 4 on the next 2. So in $1 million estate, you'd be right about 33,000. The last thing, which I don't have time to talk about, but is closing the estate. Really 2 ways to do it: short form or long form. Short form, everybody's in agreement. They'll sign waivers. Personal representative says, I've taken care of everything. Long form, somebody's not in agreement. You're going to have to get their approval. So you start with your assets. You bring in any income, any income or assets found after you filed the appraisement. You take out your debts and claims, and then you do your proposed distribution, and you verify that you've taken care of taxes, and you verify that you've changed it over in the assessor's office. I have a couple forms in here for the different types of counties. They do it a little different, a waiver of final settlement in your fiduciary commissioner counties, and that's your proposed long form. So I think that did me in. I'll take any questions and we'll move. I know Angie said we're going to take a quick break and pick right up. I want to stay on track, but even during the break, if you have a question, I'd be more than happy to answer. Yes, sir.
Suppose someone is named to be executor, and they didn't really know about it in advance. It's coming from a testator, even outside the family, and the executor wants to decline to serve. Is there a process
Yeah, there is a process. That's a good question. Actually, I had a note in there. I must have skipped over it. You can decline. So just because I'm named as executor of this person's will, I can decline. And it's a short and sweet little declination, and then it just drops to the next person in line in the will. So you normally name a couple, or mom might be incapacitated, or mom or dad might be too old. They don't want to do it, or they might already be dead. And so you do, but to answer your question, a declination is the way to go, and you just decline to serve. And then if you do have somebody you'd like to serve, you can list that in there. I don't know if that's binding, but we do it all the time. Yes, sir.
Does that also apply to someone who is nominated to be a guardian of infant children in a will?
Nominated to be a guardian, you mean to decline to serve?
Yes.
Yeah, sure, they can decline.
And it would just be a written document given to the executor?
Well, I mean, you could just decline, and then hopefully in the will it says, I want these people to be guardian. If they won't do it, then it goes here, and so forth and so on. So you would just fall down, but I don't have to be guardian. My sister can say, hey, I want you to take care of my 4 kids. And I'm going to say, no, not going to do it.
Your guardian of the minor child, even though nominated in a will, is not necessarily going to be binding on the family court, because family court is going to have to act for formal appointment. Now, if you have a married couple and one spouse dies, the natural parent is the natural guardian of that child. So that we're looking at a situation where there's no living natural parent. So all the will is doing is a nomination. So anybody can decline a nomination, but the family court has ultimate say on who's going to be formally appointed.
Thank you.
Very good. I'm going to shut it down at this time. I appreciate your attention, and we'll move on to.
Yeah, we're going to take a quick break until right at 2 o'clock. I'll give you a 1-minute warning, and we'll have everybody back to their seats, and we'll move to the next presentation. All right, it's right at 2 o'clock, so we'll move on to our second presentation by Chris Winton. For those of you that are not here, again, if you do have questions, we will take those during the presentation. If you will send them to my email address, which is volka@wvbar.org. For those of you here in the room, you can just continue doing what you're doing, throw your hand up, and I'm sure the presenter will take those questions. So I'll turn it over to Chris.
Hey, well, welcome back. I'm Chris Winton. I practice here in Charleston, and I am the current chair of the West Virginia State Bar Probate Committee. We're pretty active, and one of the things, my topic is something that the Probate Committee helped the legislature pass for you to improve and reform probate here in West Virginia. I do a fair amount of probate litigation. And last month, I was in one of our southern counties in front of the circuit court on a disputed matter. And actually, you might not think it was too technical a topic, but to the judge, it was extremely technical. I had a motion to remove a misbehaving executor from an estate. And I was making no headway with the circuit judge to convince him that he could remove an executor who couldn't even file a fiduciary income tax return. And near the end of the hearing, as the judge was ruling against me, he said, "Now, Mr. Winton, I think there's one thing you'll admit, that nobody understands probate law in West Virginia." And I said, "Yes, Judge, there are two things that no West Virginians understand. Number one is how to pronounce the word sesquicentennial, which is the 150th anniversary that we've had here in West Virginia after our state was founded in 1863. The other thing that no West Virginia understands is probate law, and the two concepts are related to each other." I still didn't win my hearing. So my topic here is simplified ancillary administration in West Virginia. Now, thank you, J.E. He gave you an overview of the West Virginia probate process. This is kind of a niche in that process, ancillary administration. Ancillary administration means that somebody has died and they had the misfortune of not being a West Virginia resident. They were out-of-state residents, but they had something valuable in West Virginia, and that was real estate. That is ancillary administration. And I'm trying to keep the excitement. We're still in January. We've got a new year. This was probate reform to get away from our probate laws from 1863. So try to remember your excitement. Fireworks on New Year's Eve. Happy New Year. We did have, our legislature passed a significant probate reform bill last year, 2019. This was House Bill 2759, and we modernized ancillary administration here in West Virginia. And this process can be done by an affidavit, and we have official affidavit even in the statute, and we in the probate bar, we're excited about that. And this can even be done long distance by mail. This is our new law. Welcome to the new year. This is the didactic trend I've kind of seen going out in our universities and other lecturers. And that's to explain things with three objects. So I want to share with you three objects, and I've got a theme that goes with it here, and that theme is, can that dog hunt? So I want to explain our old ancillary administration law in West Virginia and our new reform law with three objects. Okay, what about the old law? Okay. Here's the old law, and the theme here is a dog's life with a niche part of that theme in dog toys and a sub niche in that theme as dachshund dog toys. So here is our old law. And if you haven't figured out, yes, I do collect antique toys. Okay. Our old law is like this wonderful little toy made in occupied Japan about 1947. He's got a steel body. He does work. He can walk, but it's actually kind of freaky because he's metal body. It's got a sharp, pointy tail, and you need a key. You need to understand how to wind him up. And if no one knows where the key is, he ain't going to move. But he's cute. That's what our law is today. And to emphasize that, here's another dachshund toy. He's a wobbly toy made about 1960 in Hong Kong. Don't talk about much Hong Kong nowadays because it's part of People's Republic of China. There's no movement with this guy. He's a wobbler toy unless you pull him. So somebody's got to pull him or he's not going to move. And when you pull him, he's kind of stable and he can fall down. That's what we could do here in West Virginia with our existing or old style ancillary administration. So we could do better than this. We can have a little bit more fun. What we want is battery operated with remote control. Like this, my friend here, Doxy the Dox, and you can hear the clicking. I didn't bring a battery today, so I apologize for that. Okay. We can move him remotely. We can control him. We can get him to work. That's ancillary administration under our reform. It's a lot more fun under the new law. Okay. This applies to land in West Virginia. It applies to real estate. So if you're not in the know, you say, well, what's the issue here? Why did we have to reform probate law and specifically ancillary administration? Well, we were living under a problem last year that the legislature has improved. What was the current law problem? Here it is in a nutshell. The only statutorily authorized procedure in West Virginia for West Virginia real estate owned by a non-resident decedent was full ancillary administration. Okay. And what that meant is, as you heard from JE, you've got to get the will, you've got to get a death certificate, you've got to get a checkbook, you've got to get an executor, a personal representative, and they got to show up in the courthouse. Well, if someone out of state has to travel here to do all that, it's getting expensive. It's getting burdensome. And what do we have here in West Virginia? You know, God bless our minerals. They produce revenues, including tax revenues. People own a lot of minerals. They get fractionalized as people die, and there are small interest ownerships. If for an ancillary administration to confirm title to West Virginia real estate, somebody's got to travel out of state, come here, do all this process that could very well and generally will exceed property values of fractional mineral interests. Okay, so you have these built-in expenses and burdens in the law. So we've had some workarounds. And as Jay has told you, a very relevant thing, and that is we kind of got 55 probate systems in West Virginia. So with this ancillary administration problem, we found that county clerks were trying to do workarounds. They developed local practices and local procedures to be helpful to the citizens. That might not be that helpful because it's not statutorily authorized. And so if you're a real estate attorney passing title and you see some strange kind of affidavits filed without any statutory authority, are you going to certify title? Or are you going to have a title exception and require full administration? So that does a disservice to our citizens that you can't confirm titles. So this was the status of the law. And having worked in probate practice now over 30 years, I've met a lot of our county clerks. They are good people. They want to serve citizens. They want to do a good, efficient process of these important government services. This was high on their wish list to get some reform here, to have a simplified process for ancillary administration. And so with that, the State Bar Probate Committee, we worked extensively with the County Clerks Association and with leadership up at the West Virginia Senate and House. And we last year were able, in the regular legislative session, to get introduced through Senator Trump's office, or no, that this was a delegate Schott had introduced this, House Bill 2759. It passed last year, 2019. It was effective May 30th of 2019. So we've had this law now just 9 months, or 8 months now. So it's still new. The practitioners and the county clerks are still working out some of the edges, but we're making good improvements in understanding. That's why when the State Bar was excited to have CLE presentations, is that this was foremost in our topic. We need to educate the bar that this exists and this works really well. So what House Bill 2759 did is we amended the code sections in 41.513 dealing with testacy when there is a will, and also 44.14 dealing with intestacy when there is no will. The bill also adds a new code section 44.114B, and that deals with a publication and notice of this new process. And again, this is for land, real estate interests owned by a decedent who died not a resident of West Virginia. The most exciting part of the statute is we have an affidavit form, and it's in the statute. We have a state authorized form. Okay. So 2020, now we have two choices to do ancillary administration in West Virginia. We still have our old choice, which is if it serves the family's needs, a full ancillary administration could be done here in West Virginia. And that means a personal appearance and qualification of some out-of-state fiduciary here in West Virginia, and then you have the full process. Like Jay White was talking about, the appraisement form, the form 601, and then a filing of a final settlement to clear and confirm title to real estate. Again, it's still expensive. And I love this graphic here where Fry is saying, shut up and take my money. That's what the full ancillary administration usually was. So we wanted to kind of improve that. This is what the county clerks wanted, and we got it for them. So now, the alternative process is ancillary administration without an appointment of any fiduciary in West Virginia by an affidavit process. And this applies to both testacy and intestacy. Okay. So, when can we qualify, and what are the requirements to do the new ancillary administration? Well, I've got to break this up into two components. First component, what if we have testacy? The decedent died, having a will, and that will has been probated in another state. Okay. We can use this affidavit process in case of testacy if the decedent was a non-resident of West Virginia. Well, hey, by definition, we already got that, so that's easy. A will has been probated in another state. Okay, I already said we had to have that anyway. There's only real estate here in West Virginia. Yeah, it's an old part of the family farm, it's a mineral interest, it's the resort condominium. That's real estate. It's here in West Virginia. No appointment of a personal representative to administer the real estate in West Virginia is necessary. Okay, 4 basic provisions, and if we meet these, we can look at using the affidavit process. Okay, we are going to need an authenticated and exemplified copy of the foreign will, and that's going to be attached to the affidavit we're going to fill out, and that's going to be recorded here in West Virginia. And as you see, I've got quotations on the word recorded, because it's not really being probated. You don't have to probate it here. We're recording it here. We're lodging it here as documentary evidence. The probate has occurred in the other state. Okay. Now, we've covered this in the statute as well. And this was a somewhat frequent occurrence when we got into full ancillary administration here. You know, some states don't require the probating of a will. I've run into this in Florida, California. They have local procedures or statutes which don't require original will to be filed or probated. And basically, when you have assets passing to a spouse, or if the bulk of the assets are held in non-probate forms. So this was often a problem for us because there was no out-of-state probate, but we had the original will. So what our statute does is it allows, in this case, that original decedent's will to be recorded here with the affidavit. So the original instrument is going to be lodged here in West Virginia as opposed to California or some other state. So that topic, the statute specifically addressed. Because otherwise, under the old law, we generally had to do a lot of explaining with the county clerk's office, the fiduciary supervisor, or and a lot of times the clerk or the supervisor would say, you need an order from the county commission because I can't take an original document out of state. So we've got a great improvement here and workaround on that. Okay, so we've got a situation where the estate could qualify to go for the ancillary process by affidavit. So what is in the affidavit? And for your edification, the affidavit's set out in the statute. So let me go over that. First thing we need to know is, well, it's an affidavit, someone's got to sign it. So who can file the affidavit? And well, and I'm talking testacy now. If there's a foreign personal representative, well, they're the logical person, and they can sign the affidavit. Okay. But our statute is broader than that. It's more useful than that. The affidavit can also be filed by some other interested person. Well, who would be the other interested persons in a probate situation? How about the beneficiary under that will, who gets a devise of that real estate, including what's here in West Virginia? So it can be filled out by an other interested person. It's not limited. You don't have to. We're not relying only on the foreign personal representative. And one reason this is in the statute too is, what about this situation? The decedent died out of state. The domiciliary administration's been fully done by the personal representative out of state, but they didn't recognize or they forgot that there was West Virginia property. Okay, so the out-of-state administration is closed. Do they need to go and do a reappointment out of state and just to file a West Virginia affidavit? No, they do not, because an heir, a will beneficiary, another interested party can file the affidavit. And as I've been emphasizing here, the affidavit's set out in the statute. Okay. What does the affidavit certify? And these are not going to be surprising for you. You could probably guess them right now. This affidavit is going to describe the West Virginia real estate. Okay, and when we describe it, we're going to put down the assessed value, and we're going to put down the fair market value. Hey, is that kind of sounding familiar to you? Then J.E. White kind of talked to you about that on the appraisement form? Yes, this is kind of matching the appraisement form. Okay, the affidavit's going to set out the decedent died testate and a non-resident of West Virginia. We're going to attach that authenticated copy of the foreign will, because it's going to be recorded here. And again, you can kind of interlineate this if you wanted, or if we have the original will, because it wasn't probated out of state, it can be attached here with the affidavit. And then we're going to name some people. Okay, we're going to have the names and addresses of the personal representative. Hey, they're a player in the situation here, so they need to know what's going on in West Virginia and maybe have a duty to process property and get it administered, including what's in West Virginia. We're going to name the devisees, the beneficiaries under that will. That's logical, isn't it?
We had a question come in. Somebody asked, when would real estate need an administrator here?
Okay, the question is, when would real estate need an administrator here in West Virginia? I think generally we would not expect there would be any need. Maybe a couple of limited circumstances. One would be if there's potential issues with amongst the family, then you should probably just go the whole full ancillary administrative process and not do the affidavit, okay? Or another limited reason would be, what if the will directed the executor to sell real estate, including selling West Virginia real estate? Then that somebody should be appointed with authority here in West Virginia to deal with the title to West Virginia real estate. So that's really the most limited circumstances where I would see that a personal representative probably should be appointed here. And then that would foreclose the use of the affidavit process and require the full administration. But that's pretty limited though. Okay, and I wanted to hold that thought too, because I'm going to have a comment kind of related to that, because and at the State Bar Probate Committee, I think practically every meeting we get into a debate on real estate. Is it probate? Is it non-probate? When does title pass? When does it not pass? Is it movable? Is it shootable? We get into debates on that. So what is real estate? This is the second component of ancillary administration by affidavit. What if we don't have a will? What if we have intestacy? Okay, we can use the affidavit process, and when there is an intestacy, and let me back up a little bit, because if you're in probate practice, you frequently get calls like this. Well, I'm out-of-state administrator of my mom's estate. She died intestate. She had West Virginia real estate, so I need to come and qualify there. Okay, so I'm going to record my California intestate list of heirs and all in West Virginia, right? No, we don't want it. Okay, it doesn't do us any good. That's California saying you can qualify in California, and this person died intestate in California, and these are the California intestate heirs. We're different here in West Virginia. If you have intestacy, an out-of-state resident, you open an intestacy here, and you're administering West Virginia real estate here, and it goes to the West Virginia heirs under our statutes here, not what the other state law says. So under our new statute now, the affidavit process can be done if, and here are requirements, the decedent was a non-resident of West Virginia. The decedent died without a will. There's only real estate here in West Virginia. No appointment of a personal representative to administer real estate in West Virginia is necessary. Okay, that's follow up for what we were just talking about. That applies in the testate case too. And we've got one additional requirement here. more than 60 days have passed since the decedent's death, and no personal representative has been appointed in West Virginia. Okay, I want you to try to understand that's a little cooling off period. Well, why do we have a cooling off period here in case of intestacy? Why don't we let people the day after death rush in and do the affidavit process? Well, we've got some doubts. The doubt is there a will? Have we found the will yet? Are they looking for it? So we have a cooling off period to allow the family to find the will. Okay. And look here too. There's 60-day period. What if someone said, well, these heirs are going to fight, so I'm going to do a full ancillary administration in here, so I'm actually going to go and get qualified, and I want to do the whole process. So some heir could say, I'm doing the whole process. So if the whole process has been initiated within the first 60 days, then we're not going to go affidavit. So it's a little cooling off period here. Now, one question I get from a lot of the county clerks were asking this question, okay, well, what if they died 10 years ago? What if that doesn't matter. Is 10 years more than 60 days? Yes. 20 years is more than 60 days. 200 years is more than 60 days. So this affidavit process can be used to clean up old titles here in West Virginia. If someone will take the time, file the affidavit, the decedent has been dead more than 60 days and no one's been appointed here in West Virginia. You can use this to clear up old titles. The limitation is you can't do it within 60 days after death. 61 days after death, and anything earlier than that, you can do the process. Okay, well, we don't have a will. We're going to file an intestacy with the affidavit, a certified death certificate.
Hey, Chris, what if we have a will, but the will does not meet West Virginia formalities? Can you go over which one of these procedures you would use there and how that affects title of the real estate?
Okay. The question is, if the out-of-state will doesn't meet what West Virginia formalities, what we should do here. Well, for a will to be valid to pass West Virginia real estate, it must comply with West Virginia law. So, for example, if there's a state that only requires one extra witness on the will, and it's validly probated there, but we need two witnesses here in West Virginia, I would say that the clerk should not accept the affidavit process and should go intestacy because it's not a valid will in West Virginia. And the constitutional concepts are, hey, West Virginia land's located where? In West Virginia. It's local here, and the West Virginia legislature has jurisdiction to determine how it passes and who the heirs are. The other state doesn't do that. And West Virginia, within its constitutional limitations and rights, can restrict the validity of wills as the legislature has said. So in that case, I say and you couldn't even do that under the full ancillary administration procedure because it says if the will is valid for a will of West Virginia real estate. Okay.
Question.
Yes.
What about if you ever get into issues about whether the person's a resident or non-resident? For example, a lot of people will go to a nursing home in the next day. Does that make them a resident of the next state then?
Okay, and this question arises all the time. Do we deal with it? Yes. And again, and the question is, how do you deal with a person's residence? The easy answer, and the answer I think in most county clerk's offices is, what does the death certificate say? Okay, the death certificate says a location of death. That's not residence. The death certificate says a resident of, and it gives an address. Here in Kanawha County, the clerk's office rule is if it doesn't say West Virginia residency, they won't accept it. That's the easy answer. And then if families can fight about that. And when they come to us, when it's a potential litigation issue, we say, we have to go through the Department of Health and Human Resources, because you got to get a correction. There's an error on the death certificate. It's the wrong residence. But basically, the simplistic rule is the death certificate controls. And that's what most county clerk's offices will look at.
Are you using the word residence, same
As domicile. As domicile. And because I don't think the state governments are sophisticated enough to have it on the death certificate to say domicile. Okay. Who can file the affidavit in case of intestacy? Well, obviously the heir could do it. Okay. Or any other interested person could do it. And you might say, back to like Josh Rogers' question here. Well, what about a will, probated out of state? A personal representative could file this. A personal representative pointed out of state, because the will is good in the other state, but we're missing some formality here in West Virginia, and it's not a good will in West Virginia. So a personal representative could potentially file this here. Okay, the affidavit set out in the statute. What does the affidavit say? And again, this is not going to be surprising to you. We're going to describe the real estate in West Virginia. We're going to assess, give the assessed value. We're going to give the fair market value. We're going to identify the decedent died intestate, a non-resident without any will, probated in West Virginia or in any other state. And then we're going to have to certify that 60 days have passed since the decedent's death, and that no PR has been appointed here in West Virginia. And then we're going to list those names. So if we start to think about this and start to put everything together, the affidavit form's kind of looking like that appraisement form that J.E. has talked to you about. And it's also kind of looking like those letters of administration or that probate order that J.E. has shared with you. And yes, that is intentional, because what's happening here is that the affidavit is substituting for multiple forms that we have in the West Virginia probate process and expect to see in the West Virginia probate process. It's just that we're simplifying them. We're rolling them in to one document package. Okay. Now, what is the effect of this affidavit process if you've initiated and you file it? Okay. Well, the county clerk's going to get that affidavit and it's going to record it. It's going to be indexed, and the county clerk's going to get a fee. The county clerks wanted that in the statute. They wanted it clear. The government's doing a service for you. The government needs to be reimbursed for its services. Okay. All right. There's no bond required here. There's no security required here. There's no oath being taken by anyone here. Why? Because there's no fiduciary here in West Virginia. Okay, now that affidavit form is being signed by an interested party, right? By the personal representative appointed out of state, or a will beneficiary, or an heir at law. And that affidavit, is under penalty of perjury and all that. So don't misunderstand me. I mean, there is an oath on the affidavit, but there's no fiduciary here. There's no one acting with authority in West Virginia. We are processing documents, getting them recorded and lodged at the county level to do what? To confirm the administration entitled to West Virginia real estate. That was our goal. We wanted to make it simple. Okay, so I'm highlighting that. No one's appointed here in West Virginia. We've got an affidavit. And of course, if it's an affidavit, put it in the mail. with your check. So no one needs to come here to West Virginia. Okay. So what we've had now is we've had someone died, they had land here in West Virginia. We've qualified, we've filled out an affidavit, we've filed it with the clerk, we've paid a little bit of money to the clerk's office, and it's been recorded. Okay, now we've got some notice stuff to do, and the statute covers this. Okay. We have two basic provisions of notice that go under the new affidavit process. Within 30 days of the filing of the affidavit, the county clerk is going to publish a notice. It's a Class 2 legal notice, and it's in the local West Virginia paper. Okay, it's not going in the paper out in California or Nevada where the decedent died. It's here locally in Braxton County, in Clay County, or Ohio County. Okay, a Class 2 legal advertisement is once a week for 2 weeks. Okay.
Can I ask you about that?
Yes.
There's a pernicious bill pending in the House, HB 4025.
I know what you're going to say, but go ask your question.
Designed to, and it will actually put small rural newspapers out of business, most likely. Would that do away with this kind of requirement that the county clerk can simply put it online and hope that you have internet access in Lewis County, which you actually do?
Okay. And my answer to that would be the legislature in our overriding bill can identify what's valid publication and whether it's published on the internet locally. And I haven't read the internet publication bill to know what the language is, but I imagine the only proper way to do it would be to capture all these broad publications for various purposes that the state has to do. And I would have to imagine that that language in the bill would be broad enough to capture this affidavit process. And yeah, that's a constitutional issue. I mean, we're all attorneys, right? I mean, we can talk confidentially, right? Publication notice it's constructive service, right? We remember that from your constitutional law. It's constructive service. It's substituted service. It's substituting for something because something's wrong, something's breaking down. We're fooling ourselves. People aren't reading this. Who's reading this stuff? Maybe we are. It's like, well, maybe if I see one of my clients or maybe a would-be client, I'll catch them. But no, the Braxton County Record has very low circulation, but it's valid publication under the statute because what else are we going to do? My ultimate opinion on that is that's a policy decision for the legislature to do. We do have constitutional requirements. When the probate committee worked on this affidavit bill, we debated on this, because some people say, well, maybe we need to publish it in two places, publish it locally in West Virginia and where the decedent died, because that's where it's more likely that his or her heirs will be, and then they'll notice, hey, something's going on in West Virginia. You better take notice and protect your rights, if anything. But I leave State Bar Probate Committee, when we work on this stuff, we are politics neutral. We like to improve and advance the laws of the state of West Virginia to serve our citizens. If there are policy decisions, the legislature needs to make that. Constitution merits some type of notice here, so we have a publication in the local newspaper. Who does the publication? You file the affidavit. You've initiated the process. You're paying some money to the county clerk. The county clerk's going to publish it locally. Okay, we've got a backup here in the new ancillary affidavit process. The party filing the affidavit, it also has a duty to serve within 30 days of the first publication, a notice by mail or personal service on all the interested parties. Okay, and hey, does that look like the regular probate process? Yeah, because you've got notice of the probate of the will. At least in our office, we file an appraisement. We're going to send a copy of that to all the beneficiaries or heirs interested in the estate. You can't close the estate out with the signature on a short form, or you're mailing out a long form settlement in a normal administration. So this is not really surprising, but the affiant, the person filling out the affidavit, has to file an affidavit, and you've got a time frame here. Okay, what's the time frame? 30 days of the first publication of the notice. So we've got a coordination issue. All right, you're processing these affidavits by mail. You've filled it out. Your client's notarized it. You attach the authenticated copy of the out-of-state will. You've got the good addresses of all the heirs or will beneficiaries on your affidavit. You've paid your money to the county clerk. You've mailed it to the county clerk's office. Now, what does your client, the affiant, need to do? Certificate of service. We litigators know that, right? We do certificate of services. We know how to do a certificate of service. That's what this is, a certificate of service. But you need to notify them of what? You need to give them a notice of that publication. So the county clerks, you need to know what the county clerk's doing, and you need to know when the county clerk has published it. So this takes a little coordination. And I think in my office, we've had good cooperation, filing these with the county clerk's office, and then following up, okay, tell us when you're going to do the publication. And some of the county clerk's offices have been, honey, they always call you honey. Okay, honey, we draft that and we'll send it to you. Great, that's what we want. I want that superior West Virginia local government clerk service. Okay, well, what happens? Okay, we published it in the paper, we've mailed out a notice. What happens with that? You know, interested persons may file an objection. They've got 60 days after the first publication or 30 days after service of the notice, whichever is later. All right, and does this sound like the closing of a regular West Virginia estate? Yes. When you file your short form or your long form settlement, there's going to be a final notice that happens to be 30 days. Anybody has an objection to the closing of the estate, speak now, forever hold your peace. That's what this does. 60 days, somebody can file an objection. Okay. Then after that, the process is complete. Okay. Now, I've told you a lot, and you probably remember it, that there's a form here. There's an official statutory form here, okay? And I'll tell you another secret. And if you send me an email, I'll send you a whole package of forms, okay? Because the probate committee, we designed all these forms, and we've dolled them up and have them for all occasions, including a final form called a Certificate of Completion of Ancillary Administration by Affidavit. So if you want an entire package of forms, the probate committee has worked on them, and at the County Clerks Association meeting that they have in the summer, we disseminated the whole package of forms to the county clerk. So if they were in attendance, they got them. I've actually received a couple of phone calls from some county clerks staff saying, I hear you got forms. It's like, yeah, we do. And I'm quite happy to send them to you. So we're trying to standardize forms. We have a whole package of forms. If you want to see what the package of forms are, you send me an email. I'll be happy to share it with you. I'll treat you just like a county clerk's office, because we want this to serve people. Okay. The process is here. We've had it for 8 months now. Are there some issues with the process? We're still kind of feeling this through a little bit. It's working out pretty well, but I'm going to highlight some issues. The county clerks have raised these issues, or in discussion amongst probate practitioners, we've seen some things to try to give you some guidance if you're going to do the process here. Okay, one question would be, when is it complete? What have I done here? It's not like the probate. We want to know that the probate's done. We're going to see a county commission closing order, right? And it's going to discharge the bond and all that good stuff. So what do we have here? I filed an affidavit. The clerk's got to do a publication. The affiant's got to mail out a notice. And then we got a deadline to pass. Okay. In the forms package that we did, we have the certificate of completion that the clerk can sign and issue. And what does the certificate of completion say? It says, for this decedent, the affidavit was received and recorded on this date. A publication notice was made on this date, and more than 60 days have filed, and nobody has filed an objection. Therefore, the process is complete. So if you're new to this and running one of these ancillary administrations by affidavit, and near the end of the process, if you haven't otherwise heard from your county clerk, call him or her up, talk to the staff and say, hey, can you get me a certificate of completion? We haven't had any resistance. Some of the counties we've worked in, they just, oh, honey, they always call you honey. We'll give it to you automatically. You didn't have to ask. Some said, oh, do you have like a form? And we'd sure be happy to do that. And then we give them a form. So this is cooperative law practice with your local county government. So there is a certificate of completion, kind of like a closing order. So ask for it. Who gets notified? Okay. And the county clerks have kind of raised this issue, and we probate practitioners, we kind of recognize it too. And I think we're going to see a little bit of variance of practice among the West Virginia counties. Okay, you remember we filled out an affidavit, right? We put some names on that affidavit, right? Like heirs or will beneficiaries. We got some addresses. So you'd say, well, those people on the affidavit need to get notified, right? Well, of course. That's logical. Anybody else need to get notified? Well, the statute says you've got to notify known or local creditors. Okay, known or local creditors. So if the West Virginia real estate is a condominium at Snowshoe and Truist Bank now has a mortgage on it, they should get a notice. Just put them down on there, on the list, and they get a notice. Local creditors, well, you might say, that sounds kind of silly. Yeah, it might be silly, but it's in the statute. It makes us feel good that it's in the statute. Well, what's a local creditor? Well, maybe if the yard man hasn't been paid, or the paper boy locally, they're a creditor. We wanted to kind of protect creditors' rights, because otherwise, West Virginia real estate is, the title's being confirmed as passing to somebody, but what about creditors? So there's a little bit in the statute here to understand, notify known or local creditors. Okay. Okay, this is the big issue here that we've kind of seen, and the West Virginia counties right now already have differing attitudes on this, on who needs to get notified in a West Virginia probate. Do you notify heirs or devisees, devisees being people that get real estate under a will, or do you notify heirs and devisees? Some counties in West Virginia take the position that if you've got a will and it names a devisee, you don't need to notify the heirs at law. And they could be different people. That's the position of some counties here in West Virginia. Other counties like Kanawha County, position in Kanawha County is in every estate, testate or intestate, the heirs will be notified. Why? Because if that will cuts out an heir, they need to receive a notification so they can potentially challenge it. What does our statute do? Technically, our statute says heirs and devisees need to be notified. I expect to see that local practice may vary somewhat from that. Okay. Real estate. What's real estate? Okay. That snowshoe condominium. Got furniture, got lamps, got skis and ski boots in it. That ain't real estate, right? And didn't you tell me this statute applies only if there's only West Virginia real estate? Well, that's tangible stuff. It's located in West Virginia. So if you've got the furnished condo, you've got the furnished hunting cabin, you can't use this process, right? Our position is no, you can use that process even if tangibles are located in West Virginia. And that's because the tangibles are subject to jurisdiction in the domiciliary administration. So they're not really here. And I've told this to the County Clerks Association, and hopefully you don't get resistance on this if some clerk says, you've got stuff, you've got tangibles, so you can't use the process. Okay. What if you have real estate in multiple counties? Our position is you process it once in one West Virginia county, then get certified copies of that affidavit, it's got the will attached, and record that West Virginia certified copy in the next. You don't have to file it two separate processes. And that I think I'm very comfortable with making that statement, because if you're in West Virginia regular probate, do we need to do probate in multiple counties? If you died in Kanawha and owned property in Putnam, no. One county will do it. Okay. So in some conclusion here, yes, this is a great statute. It works. This dog can hunt, and he's really a decorated hunter. So any questions on this? Because I think I've run 2 minutes over.
We've had a multiple requests for your email since you said
Yeah.
email them your form, so
Okay.
if you can shut that out.
Look it up on the State Bar website. There's only one Winton in there. Okay, I think we have a question here in the back of the room.
Yeah, the son lives in Italy, brings mom there to live. She's in decline and she dies in Italy. I mean, this is great. This sounds all real easy, what you just talked about. But what if she dies in Italy?
Well, if she dies in Italy, you're going to get, well, first off, you're going to get the State Department involved, okay? Because you're going to have an Italian death certificate and some type of certification from the United States State Department that this American resident died out of state or out of the country. And in that regard, again, I'm going to look to the official documents to see what they say is residence on that. And maybe it's not going to be on the Italian certifications. And I think I've seen the State Department certification document, and it says, you know, a citizen of the United States, and it might even say who was a resident of so-and-so state. So the form documents I would look to first. Otherwise, if you don't have that, I would expect the county clerks would say, you know, maybe we need an affidavit from a family member, or maybe not a family member, some just interested person who knows and will certify they know the estate, like a longtime banker or a pastor or maybe even an attorney. So maybe the clerk's office would say, accept an affidavit. I know we've had to do affidavits like this in the old days in front of the county commission, when the county commission said, well, I don't like this death certificate. And we said, well, we've got affidavits from neighbors and all that say, I've known this person and they've resided at this address in West Virginia for this many years and have had a West Virginia driver's license, voted in West Virginia, things like that, which can prove domicile.
And
Okay.
vacationers are not a problem. I know a man who died in Czechoslovakia on vacation. He's a West Virginia resident, so that, I assume, is not an issue.
Yeah, that you haven't moved your residence. And the issue we get into is when you seek long-term medical care. Have you decided to change your residence? That can be problematic. And some families, we attorneys stay in business when families fight, don't we? Okay. All right. I thank you for your time. And after a short break, we're going to come back. And Josh Rogers has come from Morgantown and is going to talk about creditors' claims in its state.
All right, we're going to go ahead and get started with our last presentation from Josh Rogers today, and then I'll have a couple of wrap-up announcements at the end, and we will get you out of here by 4 o'clock. Josh, it's all yours.
Thank you, everybody. Thank you very much. And thanks for coming today, everyone. I asked Chris when we were floating the topic out here of doing a probate CLE for the state bar. I asked Chris if I could speak on this topic because this is an important topic that generates a lot of interest in West Virginia. I get a lot of out-of-state complaints about this particular topic in West Virginia and also in-state complaints from creditors in state. Both the state beneficiaries, it's funny how the complaints can come from both sides, but the state beneficiaries and creditors complain about some of the ways we handle creditor claims during the probate process here. And as Chris mentioned during his Ancillary Administration presentation, creditor rights is an important issue here in West Virginia. And as we were debating the Ancillary Administration bill, one of the things that kept us, I think, from passing an Ancillary Administration statute a little bit sooner was the fact that how do we account for creditor rights? How do we make sure that if we're just going to abbreviate the current estate administration process we already have, which is already a pretty simple process compared to most states, how do we make sure that that creditors at least get noticed, get a chance to object? So today I want to kind of approach this as I go through this. I'm going to share some of my opinions on how we handle creditor rights here in West Virginia. I'm going to approach it, some of the slides from both the probate practitioner, if I'm representing the executor or the personal representative, but then also from the other side, if I'm representing the creditor, how do I make sure that my client gets paid to the extent that there are probate assets to pay my client? So I'm going to try to approach it from both angles as we go through here. So my name is Josh Rogers. I am a partner with Dinsmore & Scholl. My primary practice focuses in Morgantown and the north central part of the state. I do some things down here. I'm a member of the State Bar Probate Committee as well, so I do try to make it down here for those meetings. But primarily, I practice up in the north central part of the state, where procedure can differ drastically depending upon what county you're in. As Jay White already joked earlier today, 55 counties, 55 different probate systems, and really, I do mean that. The way that the counties, even neighboring counties, can handle some of these issues can differ drastically depending on who you're in front of. And sometimes it can differ from fiduciary commissioner to fiduciary commissioner, from county clerk to county clerk, even in the same county. So it really just depends on the local practice in some of these areas. But generally speaking, probate here in West Virginia, Jay already covered some of this, so I won't spend a lot of time on the slide, but probate here in West Virginia follows as we deal with creditor claims, follows two different procedures. Most counties here follow the fiduciary commissioner procedure. It's the one that I'm most used to because of Monongalia County, Preston County, a lot of the counties that I practice a lot in, Harrison County, follow the fiduciary commissioner procedure. That is under Chapter 44, Article 2 of the Code. There is also an optional fiduciary supervisor procedure. And J.E. mentioned, J.E., my count's the same as yours. I count 8 counties right now that are following the optional fiduciary supervisor procedure, which is under Chapter 44, Article 3, Cap A of the Code. And I listed the counties right now that at least I'm aware of that follow this optional fiduciary supervisor procedure. And the main difference is there's a lot of similarities, but there are some differences because in the fiduciary supervisor counties, they have actual county staff person, someone who's on the county payroll, to deal with a lot of the probate issues that possibly in the fiduciary commissioner counties would just automatically get kicked out to a fiduciary commissioner, who's usually a private practice attorney, just happens to be in that county. So there can be some differences. We're going to talk about a few of those differences as we go through the presentation today, but I've listed the 8 counties that I know about. Does anybody see a fiduciary supervisor county that I've left off? The one that I'm most familiar with is Marion, because it's right up there by Monongalia County. So I am familiar with the fiduciary supervisor proceeding and procedure in that county as well. So, okay. So the first thing that I usually get asked about is when do fiduciary commissioners get involved? Okay, who actually handles the processing of creditor claims? If the estate is open and a creditor comes in and files a claim, when do fiduciary commissioners get involved, and when can the county clerks just go ahead and process that estate administration without getting a fiduciary commissioner involved? So there's actually 2 different answers here depending on which county you're in. In the fiduciary commissioner counties, this is Chapter 44, Article 2, Section 1. The threshold is $200,000 or more in probate assets. So Jay went over earlier this afternoon the difference between probate and non-probate assets.
The threshold is $200,000 or more in probate assets, exclusive of specifically devised real estate and non-probate assets. Or if there's more than one beneficiary. So in fiduciary commissioner counties, if there's only one beneficiary and there's $1 million in probate assets, you still don't have to get a fiduciary commissioner involved. Unless there's an unpaid creditor files a claim. So an unpaid creditor files a claim, and generally what happens in the counties that I usually practice in is the county clerk will notify you. So if it's a state that otherwise has not had to be referred to a fiduciary commissioner yet, the county clerk will send you a notice, say somebody's filed a claim. You have 20 days to let us know if you agree or disagree with this claim. The statute provides you with 20 days. If we don't hear from you, or if you say, I disagree, then we are going to refer that estate out to a fiduciary commissioner to handle the claim. Okay. If you write back and you say, I agree with the claim, we're going to get them paid. We just need to get through the estate administration first. They usually keep it without going out to a fiduciary commissioner. Why does that matter to your client? Because if it goes out to a fiduciary commissioner, it can mean more fees for the estate, obviously, because the fiduciary commissioner, private practice attorney, and even though fiduciary commissioners don't get paid much here in West Virginia, all different topic for a different day, it's additional fees. So if you can keep it out of the hands, and if there's no need to get a fiduciary commissioner involved, you got to make sure that you let the county clerk know that you agree with the claim within 20 days. Otherwise, it gets referred out. If you don't answer, then they will refer it out to the fiduciary commissioner. But that doesn't necessarily mean that the claim is proved yet, that the claim is that the personal representative still can't object to the claim. So, and then here, this same statute here discusses what the fiduciary commissioner can charge. They generally can only charge $300 per estate plus expenses, unless, and in most counties, I've found that there is a county commission order out there somewhere that says if the fiduciary commissioner has to have a hearing, and we'll get into that procedure in a minute, or if there's some specific issue that comes up with the estate where they have to devote more than the time that would typically be allowed or typically be required to do and to be the fiduciary commissioner for an estate, that they can actually charge a reasonable hourly rate, or they can charge for their time. So fiduciary supervisor counties, it is a little bit lower of a threshold right now under the statute, $100,000 in probate assets, but there are several exceptions. Okay, so under this code section, there are several exceptions, and they also have the sole beneficiary exception as well. So even if the probate assets are over that, the whole point of adopting a fiduciary supervisor type of system is to keep as many estates as possible at the county level, not have to get fiduciary commissioners involved. So there's a whole host of exceptions under this Section 5 of Article 3A of Chapter 44. So. Okay, so creditor claims. So if I'm representing the creditor of an estate, there is a specific way that I have to file claims. And this is very important because, again, the practice can vary from county to county. So I've seen, technically, the statute requires that the claims must be proved by vouchers and affidavits. Okay, and that is in both counties. I give you the code sections here, but they have to be proved by vouchers and affidavits, and the code section is actually very specific. So it's not just a matter of going down there and filing a letter saying, I've got a proof of claim here. You got to actually file affidavits, you got to file a voucher, and actually file something in support of the claim. All right, that means different things in different counties. I've seen some county clerks or fiduciary commissioners reject a claim that is not accompanied by proper vouchers and affidavits, and then I've seen some people take a much less standard for what it takes to actually file a claim against an estate. So it's important to know the proper practice. In Monongalia County, where most of my estates are, we actually enforce the rule up there that they need to be supported by an affidavit. Again, you can't just write a letter to the clerk saying, I have a claim against this estate. It needs to be properly supported. Objections to claims. So somebody's filed a claim against one of your estates, and it is the personal representative does not agree with it, or the family does not agree with this claim. We think we do not owe this money. See this a lot of time with credit cards, things like that, hospital bills. They think it's something that Medicare or an insurance carrier should have picked up on. We need to file a counter affidavit, is what the statute requires. So a counter affidavit that actually objects to the proof of claim, and to let the fiduciary commissioner know that we actually disagree with the claim that's been filed, and a hearing needs to be set on it so that we can determine the validity of the claim. So in fiduciary commissioner counties, the personal representative must comply with Section 44-2-6, and fiduciary supervisor counties, the statutes are very similar. They need to comply with 44-3A-7. Now, one thing that I sometimes do in my practice, I get this a lot, especially in situations where the families don't necessarily agree, is let's just say we've got a personal representative, and this happens all the time. They personally pay the funeral bill. Because, you know, you go, you have the funeral for the decedent, the estate may not be open up, or you may not have access to liquid assets of the estate for a month or two. And somebody's got to pay that funeral bill, or somebody signed on the dotted line to be responsible for the funeral bill if the estate isn't open for a while or the estate can't pay for a while. So I will sometimes file what I like to call a protective proof of claim, or a proof of claim on behalf of my clients. Even if my client's a beneficiary of the estate, or they're the personal representative of the estate, I'll file like a proof of claim, and I'll explain why, because there is an order of priority here. And if we think there's a situation where my clients advance certain expenses, it doesn't even have to be funeral expenses. Maybe it's just the expenses to open up the estate, or the initial retainer to the attorney to get the estate rolling. I want to file a protective proof of claim, at least get that. Again, don't do it in every estate, but I do it in estates where I think that there might be fighting among the family, or somebody may disagree with my client's right to reimburse themselves at the end of the estate administration. So sometimes I will file sort of a protective type of claim on behalf of a beneficiary. Again, priority becomes an issue, and we'll get into that in a few slides. So the key here is, if you're going to object to a claim, it needs to be in the form of a counter affidavit. Again, filing like you would an answer in a civil lawsuit that sometimes is not verified, or said where you're just signing your signature, or a letter from counsel stating that my client objects to this claim, is not technically enough under the statute. And some counties will hold you to this. It needs to be in the form of a counter affidavit. Okay, so make sure you're complying with the technicalities of the statute when you're filing claims, or when you are filing a counter affidavit. Okay, so provisions for contingent and unliquidated claims. So sometimes I get situations, and I personally haven't used these statutes very much in my personal practice. I think I did once, where a claim's been filed and it may be years. It's what we call a contingent or an unliquidated claim. We don't know the amount. The creditor just knows that the estate owes us. We need to litigate the amount, or the amount needs to be determined how much is actually owed. So sometimes there will be a claim filed against the estate, and then there's a companion case going on at circuit court to determine how much is actually owed on the creditor claim. And the estate beneficiaries are beginning to chirp or get upset with the personal representative, saying, how long are we going to have to wait to get any assets from this estate? And actually the code provides some again, I don't use this very often. A lot of times I just tell beneficiaries, until the estate is closed, we're not going to make distributions. There's nothing per se wrong with making partial distributions in West Virginia, but they are what we call at-risk distributions if you make early distributions before the estate is closed. So if there is a claim that ends up you've distributed too many assets, you don't have enough to fully pay the claim, then you got to be careful. I have had estates where I make early partial distributions, but a lot of times I won't do that until the estate is closed. But actually, there is a procedure you can follow in the code if there are situations where there are contingent and unliquidated claims. Maybe the amount won't be known for a while, but you want to go ahead and get the beneficiaries some money. And under these code sections right here, in fiduciary commissioner counties, it's 44-2-17. Fiduciary supervisor counties, it's 44-3A-9. They're actual sort of a sit aside that the fiduciary commissioner can authorize you to do, where they say, all right, we know we have this claim out here. The probate assets of the estate are worth $500,000. We know the max amount of this claim is going to be $100,000. So we'll withhold $100,000. We'll hold it back. But fiduciary commissioner, go ahead and authorize me to distribute the remaining $400,000 as long as you're comfortable. The creditor claim period's already run. We know we got this one claim to deal with, but we know that there's no other asset, the creditors of the estate we have to worry about. Go ahead and authorize me to distribute the other $400,000 to the beneficiaries of the estate. And these are the code sections that you can rely upon to do that. Now, this does require, if you're going to rely on this, the distributee or the legatee to post a bond. Okay, so if you're going to do this, it requires them to post a bond that if you're surprised and the creditor claim comes back and is actually more than the assets that you've held back to cover it, they got to post a bond saying that they will make up the difference. out of the assets that they've already received. So it does require a bond, which is probably why I personally haven't used this very much. I've found that getting estate bonds or bonds with anything estate related has become more and more challenging since I started practicing 15 years ago. Insurance companies are not as willing, from what I've seen, to post estate bonds as what they once were whenever I first started practicing. So this can be a difficult procedure to use, but it can sometimes be helpful if there is pending litigation or something holding up the estate, but you want to go ahead and get some assets. It doesn't make sense to hold all this liquidity in the estate, for example. Another situation where this could become helpful, I don't want to get too far down into the tax weeds, but we do have situations, not where good estate planning was done, but we do have situations where a retirement account or some type of income in respect of a decedent was payable to the estate. And for income tax reasons, we want to get that income out of the estate into the hands of a beneficiary, because generally speaking, beneficiaries pay income taxes at much lower rates than estates do. So we want to pass some of the liquidity out of the estate to a beneficiary of the estate, so that they pick up the taxable income on their own personal return, and we don't have to pick it all up on the estate income tax return that Jay was telling you about earlier today. That's another issue where you could, if due to a timing situation, again, I won't get too far down in the weeds in taxes today, but due to a timing situation, you may want to get some money out of the estate into the beneficiary's hands for tax reasons, even if the estate is not closed yet. Okay, that might be a situation where you want to make an at-risk distribution, especially if you know you have enough to cover other creditors' claims. So that hopefully won't happen, because hopefully people are getting proper estate planning. But last I checked, still a majority of West Virginians don't have wills, and they don't always follow up with the beneficiary designations of their non-probate assets and things like that. So we have to deal with a lot of estates where things are payable to the estate and become probate assets that with proper estate planning would not have been probate assets. So that's another situation where you may want to take a look at these two code sections if you got a situation like that. Other thing that I see sometimes is, does filing a claim toll the statute of limitations? So I know this person owed me money, whether it be a breach of contract lawsuit or whether it be a car accident where the decedent passed away, but his estate owes me money because the car accident was the decedent's fault. Does filing a claim against his estate toll the statute of limitations for filing that claim, the same as it would by filing a claim in circuit court? And we've actually got two code sections here. Again, fiduciary commissioner counties, it's section 13. Fiduciary supervisor counties, it's section 14. It says, yes, it does. So filing a claim against an estate does toll the statute of limitations on a civil suit, some of the examples that I gave. The common practice and what I personally do in a situation like that, though, a lot of times you don't want to be litigating a claim like that or handling a claim like that before a fiduciary commissioner who's not getting paid very much to really pay much attention to it, or before a county commission. A lot of times what we want to do is we'll file a protective claim, what I call a protective claim. You won't find that in the statute, but that's what I call it. You file a claim against the estate, supported by affidavits, vouchers, even maybe include a copy of the complaint that you're going to file in circuit court, and then you go litigate the actual action in circuit court. Okay, so very rarely do you want to stay in county commission to litigate these types of claims, but you file a claim in the estate. That way everybody has notice that there is this lawsuit pending. All the beneficiaries, all the potential other creditors of the estate have notice that the lawsuit is pending. But then a common practice is to go ahead and litigate the claim in circuit court. What I like to do is I'll put a claim together, supported by an affidavit, but then also attach a copy of my complaint that I filed in circuit court. Okay, so a common complaint, as I said at the beginning, is about the West Virginia probate system is there's inadequate notice for creditors. I get this complaint a lot, and this is something that we've talked about looking at the State Bar Probate Committee. We had this discussion earlier today about, you do this publication in the paper and nobody really pays attention to that anymore, or people don't look closely enough at that anymore. And how are we supposed to know that the debtor died? How are we supposed to know that we need to file a claim against the estate? Because I believe Jay went over this earlier. Once that appraisement of the estate is filed, that form ET 6.01, and the clerk publishes notice in the paper, there's a very tight window. a 60-day creditor claim deadline by which creditors need to file their claims in order to be timely paid. Now, I'll cover at the end of the presentation, doesn't necessarily mean the creditor's out of luck if they miss that 60-day window, but that 60-day window comes and goes very, very quickly. Now, of course, they can file their claims before there's an appraisement filed even. They don't have to wait for that, but a lot of times that 60 days comes and goes very quickly. So right now, what our law provides for is the county clerk or the fiduciary commissioner or supervisor publishes notice, and the argument is that enough? Well, there is this code section here, 44-1-14A, and then subsection D, does require the personal representative. Under that code section, the personal representative of the estate is supposed to use due diligence to ascertain the known creditors of the estate. So you're supposed to use due diligence. So what does that mean? It might mean doing a UCC search, obviously checking the public records to see if there's a mortgage or a deed of trust, as we call them here in West Virginia, out there of record, or are there other liens of record? Are there tax liens of record? Are there judgments or abstracts of judgments recorded out there from previous lawsuits that have not expired yet? Are there known creditors of the estate? If you're getting the decedent's mail, are credit card statements coming in? I mean, anything like that you're supposed to use due diligence as the personal representative to actually try to track these creditors down, because you are supposed to, when the clerk publishes that notice of administration in the paper, you're supposed to take a copy of that notice of administration and send it to all the known creditors. Now, in some counties, the common complaint I get is the personal representative didn't do that. They just didn't give me notice, and they either knew or should have known about me. And really the issue here is that these statutes don't have a lot of teeth. There's also in fiduciary commissioner counties, this section 44-2-4 that says that if the estate's been referred to a fiduciary commissioner, you're supposed to provide the fiduciary commissioner with a list of the known creditors of the estate, if you're the personal representative. But a lot of complaints are, they just didn't do that. They didn't know about me or didn't use due diligence to find out about me so that I would have received notice and known to file my claim very timely. So the statute actually protects the personal representative here. And if you look at 44-1-14 it specifically says, subsection F of that section says, a personal representative acting in good faith who fails to serve the notice required by this section is not personally liable. Now, I don't do a ton of litigation, but I do know how hard it is to prove that somebody acted in bad faith. So a lot of times these windows are missed here, and it all comes down to, did the personal representative exercise due diligence to try to look for the known creditors of the estate? Now, if you got a deed of trust or some secured claim out there and there's real estate, you're probably not as worried about it because your lien is going to be there against the real estate before it can be sold. You know you're eventually going to be paid. But it can become a major issue if you're just a general creditor, a credit card company, a hospital, something like that. So in some counties, Montague and Preston County in particular, they make the personal representative, before they will close the estate, file what we call an affidavit of mailing notices. You won't see that in the code anywhere, but we actually require, before you can close the estate, an affidavit of mailing notices that says, and at least gets the personal representative and counsel thinking, like, geez, do I know about creditors, and should I have put these people on notice? Should I have sent them a copy of the notice of administration? In some counties, they require that. There are other counties where I've sent them an affidavit of mailing notice, and they call me and say, what is this? And they send it back. They say, we're not doing that in this county. So again, it's still back to 55 counties, 55 different probate systems. But this is a hot issue in West Virginia, and something that I think we might look at as a probate committee. Are there extra things that we could be doing, maybe adding a little bit more teeth to these statutes if it's shown? But again, it's a good faith standard right now, and it's hard to show bad faith. So unless there is just a blatant situation where the personal representative absolutely knew about it and just didn't send the notice, it's hard to get around these creditor claim deadlines. So the lesson is, if you represent creditors, banks or whatever, you need to be paying attention to the obituaries. You need to be paying attention to people who owe you money to make sure that you're timely filing your claims. In Morgantown, the hospitals are very good. I mean, from what I've seen, they are a lot of times they filed the claim before the families even come in to hire me. That's the first thing I find is there's already been a claim filed. Credit card companies are also very, very good. That's what's one of the first things that you tell the personal representative when they come in to see you. Call the credit card companies and cancel the credit cards right now because it's you don't want charges being made on those credit cards after the decedent has been passed away. Call and put them on notice. Well, once the credit card company has notice, they usually contact DCM services, estate recovery services. There's several different types of entities out there that specialize in making and filing claims against these types of estates. So West Virginia's got a little bit of a different system here in terms of notifying people, but a lot of times the more sophisticated creditors, they already know about it. A lot of times before your clients even hired you. So, but it is a problem that gets raised with us sometimes. So. There is an order of priority that we are supposed to follow when we're dealing with creditor claims. And this is why timely filing your claim is so important, especially if you're in one of these higher levels of priority. Because, for example, if there's unpaid child support out there and your client didn't file his or her claim timely, then some of these on the lower chain of title can jump them in terms of getting paid. And if there are limited probate assets of the estate, which is a common occurrence now in today's estate administration, estate planning climate, a lot of times there aren't many probate assets to collect from. You can actually get jumped in the order of priority if you don't file your claim timely. So the first one that gets paid, I always joke with clients, you can tell who drafted these statutes because costs and expenses of administration, and that includes attorney and accountant fees. So we get paid first. The other thing that gets paid first out of this is the client's, the executive, if you're representing the personal representative, the executor's fee or the administrator's fee. Jay showed you the statute earlier. One thing to think about when you're doing some estate planning or when you are doing some estate administration work is think about how that fee is calculated. And Jay went through it briefly this morning, but one thing that surprises people that is a lot different from what I've seen in other states is not only does the executor get a certain commission of probate assets, so it's 5% for the first $100,000, and then it's a cascading CL after that. You also get 1% of all non-probate assets. I think the exact language the statute uses is all assets that are included in the decedent's gross estate for estate tax purposes, which for purposes of today's discussion basically means everything the decedent owed, not just probate assets, but non-probate assets as well. And I've seen that cause a lot of issues, a lot of family heartache, because in today's climate where everything has a beneficiary designation, it seems, or we have a lot of transfer on death deeds and things like that, the non-probate, and a decedent could pass away with maybe $10,000 of probate assets, but $10 million of non-probate assets. And if you have 1% of a significant value of non-probate assets, that can eat up all of the probate assets of the estate right there. So if you're representing an executor, executrix, administrator, and there are claims, but they're lower in priority, sometimes you can use that as a bargaining chip for your client to say, look, by the time my client pays me, by the time my client takes his or her fee that they're due under this statute, which includes a 1% fee on non-probate assets that, by the way, creditor, you don't have access to. By the time you include all of that in there, there's not going to be anything left for these lower level creditors anyway. So you should take 10 cents on the dollar and go away and give us a release. So, and we'll get into some of those negotiating tools here in a second, but that's an important part. And be thinking about that too if you do any estate planning, because I've also seen that cause fights among the family members. Like dad never would have wanted her to have 1% of those non-probate assets that she didn't even have to add an estate dispute case about that one time. And the statute says 1% of non-probate assets, where again, that very example happened. The decedent had significant non-probate assets, not much probate assets, and the client, who is the executrix, walked away with a significant fee, 1% of the non-probate assets, even though she never had to do anything with the non-probate assets. The beneficiaries turned in their beneficiary designate or their beneficiary claim forms, and the money went straight to the beneficiaries because they were non-probate. So guy had a lot of assets in a brokerage account that had a payable and death beneficiary on it. So that's just something to keep in mind, not only when you're doing estate planning, but also as you're negotiating. Reasonable funeral expenses come second. That's also why sometimes if I know, especially in a state that's going to be close to insolvent, and my clients advance the funeral expenses, a lot of times they come in to see me. If they come in to see me first, I may say, hold off on paying those funeral expenses. I'll call the funeral director. We'll get him or her paid. We'll get the funeral home paid, but don't advance it out of your own pocket yet, because that can become a little bit messy. But if they've already advanced it out of their own pocket and you think that this estate may be close to insolvent, timely file a claim for your client. That preserves their order of priority here. They're second in line to get paid if they've advanced funeral expenses. Reasonable funeral expenses are second in line here. Next are debts and taxes with preference under federal law. If there's an IRS lien out there, I don't know if any of you have had to deal with the IRS and trying to get a release from them so that you can go forward and close an estate. That's never an easy situation, especially if if there's insolvency and there's not enough assets to pay off a federal tax lien, for example. That's not a fun situation, but they are third on this list. Unpaid child support, debts and taxes with preference under state law. Dealing with the state tax department's a little bit easier than the IRS, but that is also can sometimes be tough to get a release if there is a insolvent estate situation. So that's the next reasonable and necessary medical and hospital expenses for last illness. And then last and least, I guess if you will, credit card claims, other claims. And a lot of times this is where your credit card claims or your general creditors come into play. Great bargaining chip that you can use to try to knock some of those claims out very early in the estate administration. Note that secured claims, so if there is probate real estate out there, real estate that the executor has some control on because of the will, and we'll get into the differences here in a minute, but if there is real estate that is passing through the will, a deed of trust is always going to have priority, of course. Secure claims always have priority there. Or if the client was a business owner, or something like that, there might be a UCC lien out there. Got to do your due diligence and make sure there's no claims out there or liens, because they always get priority. Secure creditors always have priority over all these other types of creditors. Okay. So the reason that it's important to make sure that your client's claim, if you are representing the creditor, is timely filed again, is even if you would be up here, if you don't timely file it, you can drop all the way to the bottom. Okay. Or if your client is in this mix down here, but you don't timely file, but the others do, you're not going to get paid unless there's money left over at the end. So it can become a massive issue when there's not many probate assets. Okay, so insolvent estates, and this is just my personal observation, but one of the new statutes that if we have time we'll talk about here before the end of the day, the unprogressed estate statute that the probate committee worked on and actually was passed last year that just became law in May of 2019. There's a new unprogressed estate statute. This is a major problem for the county clerks where estate administrations have been opened, but for whatever reason, they've never been filed. They've never been closed. The executor has never, or whoever, the personal representative, the fiduciary commissioner has not taken the actions necessary to finalize and close the estate. In my personal observation, the number one reason for that is because we have an insolvent estate. We have a situation where there's a creditor claim filed out there. There's no money to pay it. The estate doesn't know what to do. The family doesn't know what to do because there's no money to pay the claim, and the creditor won't release the claim. So it's literally just sitting there with the fiduciary commissioner, and nobody knows what to do to push this ahead to actually close out the estate. In my opinion, it's a major issue here in West Virginia that we probably need some clarification on, because a lot of the problem is a lot of our probate statutes were written a long, long time ago and don't necessarily comply with modern civil procedure and things like that. So I do think there is a statute already written on the books if we cannot get releases. Now, the best practice is to try to work with the family to get a release. And I'll walk through some alternatives here in a second. But there is a statute already, or there is a statutory framework already in place. And I walk through that in the PowerPoint slides if you can get the fiduciary commissioner to do it. But what I've found is a lot of times the fiduciary commissioner doesn't want to push forward and do this because it requires having hearings and things like that. And again, they're very limited on what they can charge in terms of being a fiduciary commissioner for an estate under the statute. So it's a procedure that I've used before, but it's hard sometimes, and it can vary from county to county whether you can even do it or whether they'll even let you do it. But if there is a claim that has not been released, you have to use what we call a long form settlement. It's referred to fiduciary commissioner, even in regardless of which county you're in. The fiduciary commissioner is supposed to issue, if there is a claim that's been filed and then a counter affidavit filed against it, the fiduciary commissioner is supposed to have a hearing on that claim to determine whether it's valid or not. Is it a valid claim against the estate? And then the fiduciary commissioner issues a report of claims saying, yes, this claim is valid. Here's how much they should be paid based upon this, this order of priority that we just went through, or they shouldn't get anything. Yes, the claim may be valid, but there's not enough assets in the estate to pay it, whatever the report of claims may say. Then either the personal representative or any interested party or the creditor may file an exception to the report of claims. So there's supposed to be a hearing on the report of claims and exceptions before the county commission. And again, money's being spent this entire time, and if the estate's insolvent, a lot of times your client's paying you out of their own pocket if they're the personal representative. So usually it doesn't get this far. We're usually able to achieve some type of settlement here. But if we're not, then there is a hearing before the county commission. As Jay explained this morning, the county commission's the first level on most things probate in West Virginia. Depending on what the county commission decides, you can also appeal it to the circuit court and, if necessary, the Supreme Court. And then once the report of claims has been exhausted, all appeals have been exhausted, the report of claims is supposed to be recorded once confirmed by the county commission after it comes back from appeal if it's gone on appeal. And it becomes final and binding, and the estate proceeds to closure. That's the way it's supposed to work. I know I kind of went through that briefly. That's a lot of work, though. It takes a lot of money, can take multiple years to complete, depending on the situation. So here are some practical solutions that I've used whenever I've got an insolvent situation. And by the way, I think this is going to become a bigger problem in West Virginia, insolvent estates, insolvent probate estates. Because as I said, we live in a world now where most assets have beneficiary designations. Retirement accounts, life insurance policies, brokerage accounts even some banks, my understanding, will let you put like a payable on death designation on money market accounts and things like that. So very few assets now are passing through the estate, especially if proper estate planning was done. Very few assets are passing through the estate now. There's less and less, I always joke, the will's becoming less of an important document. Now, we even have a transfer on death deed statute now that allows you to designate a revocable beneficiary on a piece of real property just by doing a transfer on death deed. So there's less probate assets for these creditors to collect their claims from the decedent now. So I think insolvent estates are going to become a bigger issue than they already are. But some options here that you can try to do. Number one, show the creditor the insolvency. Some of the credit card companies are good about this, some of them aren't. But show the creditor the insolvency. Write a letter as a state counsel saying, here's a copy of the appraisement. There's no assets available to pay you. I'm sorry. And try to convince them to release the claim or withdraw their claim. Sometimes that works, sometimes it won't. Another technique I've tried before is you speak to the family and say, look, there is a procedure. You don't have, you're right, family. You don't have to pay this creditor anything. There's no probate assets here to pay them with. But it's going to take a long time, and you're going to spend a lot of money to go through all these, county commission hearings and everything else. So why don't we take some of the non-probate money you inherited, life insurance or whatever, and offer this creditor 10 or 20 cents on the dollar, whatever you may be able to negotiate for your client to give you a release. And I've had that one work a lot of times. Say, look, I know your claim is $1,500. None of us want to fight about this. My client will give you $100. There's no probate assets. Here's a copy of the appraisement. You're welcome to challenge the appraisement if you want, but I'm telling you, there's no assets out there, no probate assets out there. Here's $100. Will you just give us the release? So that's a technique that I've used before. Another technique that will work in some counties, not in others, is file the long form settlement. That's the technique I just went through, and push the fiduciary commissioner to try to push towards closure. It puts a burden on the creditor to actually hire counsel here in West Virginia, or to show up at the hearing and actually contest the procedure. Puts a burden on them. For a $2,000, $3,000 claim, they're probably not going to do that. If it's a significant claim, then they might. But that's another. Again, some fiduciary commissioners will do that and follow that process. Some fiduciary commissioners won't. And then one of the things that Chris talked about, how busy the probate committee has been in the last couple of years. There is a brand new unprogressed estates statute. And this is the section here, 44-2-19, little a. It's a new statute that, and in fact, some of your clients, if you do any of this type of work at all, may have got some of these, if the estate's been open for longer than 3 years, they may have already received some of these notices. What the unprogressed estate statute does is, I encourage you to go to the statute and read it because it's somewhat detailed, but basically if an estate has been open for longer than 3 years, And in the opinion of the county clerk or the fiduciary commissioner, it is unprogressed, meaning that satisfactory progress, nothing's been done on this estate in a year, and it's not making satisfactory progress towards closure, and it's been open for longer than 3 years, then the county clerk goes to the county commission and gets the county commission to issue what we call an order to show cause that goes out to the personal representative, all the beneficiaries of the estate, and all the creditors who have timely filed claims against the estate. All the creditors whose claims have not been rejected, or whose claims have not already been paid and released. They send this notice, an order to show cause, say, come within 30 days and give us a reason why this estate has not been progressed. Why is it still open? If there is no response within 30 days, then at that point, the county commission or the county clerk reports back to the county commission. A hearing is scheduled. And again, if nobody shows up at this hearing to determine why the estate has not been closed, then at that point, any person interested can file an objection at any point about why the estate should not be administratively closed or the personal representative removed. But the county commission under this statute does have the power to administratively close estates. Okay, and this is a technique I haven't used yet because this just became law May 29th of 2019. But if your estate's been open for a while and it's because of this insolvent estate issue, try to push the county clerk to close it under the unprogressed estate statute. I mean, that's another option. Say, hey, look, I've got this estate, nobody's doing anything on it. I can't get it closed because there's an unfiled claim out there. Can you essentially force it to be closed? And that's a new statute that has a lot of teeth for the county clerks to try to. There's a lot of background behind why that statute was passed. I don't have enough time to get into it in the 7 minutes I've got left here. But something to keep in the back of your mind. It's another tool for the practitioner to try to get estates closed that aren't moving along very closely or very good. So, all right, a topic I wanted to spend more time on, I'm going to kind of go over it briefly. But this is a common, what I found to be somewhat common. I've had to handle several of these types of cases where, let's just say the probate estate has no personal assets to pay claims. So there's no personal property, whether it be tangible personal property or cash or anything that's part of the probate estate to actually pay the claims. But the decedent died owning real estate. And the real estate is not specifically devised to be sold, okay? So if it's specifically devised to be sold, and I've drafted some wills like that that says, I direct my executor to sell the real estate in no uncertain terms. That's a different story. You don't have to go through this procedure. At that point, the executor can sell the real estate to pay any creditor claims that may be out there. The issue in West Virginia is if that language is not in the will and is specifically devised to another beneficiary, or it is just left in the residuary clause to the decedent's family or their children or whatever it may be, and there's not sufficient assets to pay the claims, then you can actually then the personal representative can initiate a civil action in circuit court to try to subject that real estate to the claims of the estate. So real estate in West Virginia, we are what we call a title shooting state, meaning that immediately upon the decedent's death, title to the real estate vests automatically in whoever receives it under the will, or if there's no will, then under intestacy, which Jay went through, the heirs of the estate. We're a title shooting state. But I always, when I'm trying to explain it to clients, and Chris is right, we're always getting these debates on the probate committee. Is real estate probate? Is it not probate? It's a tricky issue, but I always explain it to clients, yes, it's yours already, but it's subject to the right of the personal representative or a creditor to pull that real estate back into the estate to force it to be sold to pay creditor claims if there are not enough personal assets. That's the only way I know how to explain it to a client. So yes, you are the owner as of date of death, but it can be pulled back into the estate to be sold to pay creditor claims. And the statute actually allows a creditor, if nothing's been done within 6 months, the creditor can actually initiate this action. Say, okay, there's no personal property available, but I'm going to initiate an action to force this real estate that passed under the will or passed under intestacy to be subject to creditor claims, okay? It's a long, complicated process that you got to go through. Most of the time you want to go to the family and say, look, try to work out some family settlement agreement that says we don't have enough claims to pay, or we don't have enough personal assets to pay these claims. I've talked to these claimants. They're not going to otherwise give me releases. They're not going to go away. If you want to get them paid, why don't we just enter into an agreement to sell the real estate? Avoid the circuit court action, because the circuit court action can be somewhat difficult. The other thing about the circuit court action, so it involves, in the statute here, 44-8-7, involves filing a complaint involves giving notice to a lot of people, involves naming a lot of different parties, getting them served, a lot of expenses here. And the worst thing about it is most judges, in my experience at least, take the position that they don't have the right to families say, well, can't we get a professional auctioneer or a professional realtor to actually market this for us? The statute technically requires, some judges will do that, the statute technically requires that the real estate gets sold on the courthouse steps. So I've actually had estates where I've had to play auctioneer on the courthouse steps before. And that is no way to get the best fair market value out of it. Sometimes it works out, sometimes it doesn't. It requires you to publish notice and then do the sale actually on the courthouse steps. I've actually had to do that a couple times. Usually not a good situation here. So again, it's not something that not a process you want to go through, but it is available out there for the creditor if there are no personal assets, but there is real estate that could be subjected to the debts. At the end of the proceeding, there is what we call a decree of distribution issued, where the judge orders who gets paid, and following the statute, the order of priority and things like that. So proper estate planning a lot of times can avoid all that if you do a transfer on death deed. So, most of you probably already know about this. It isn't necessarily brand new in West Virginia anymore, but it's still relatively new, but it's not brand new anymore. Section 36-12-1 et sec, there's a new transfer on death deed statute where you can actually do I do at least probably 3 or 4 of these a week. I love the transfer on death deed, where you go ahead and you record, you draft a deed, but it's a revocable deed. Your client goes ahead and signs it. You go ahead and record it as though it was a real deed, but the client is reserving the right to change the beneficiary of that property at any point during his or her lifetime, as long as they're still alive and competent. But upon their death, the transfer on death deed statute specifically says this is a non-testamentary transfer. It is not subject to creditor claims. All right, it's a non-probate transfer, so it's not subject to creditor claims of the estate. Statute hasn't been around for very long. Maybe there's ways to poke holes in it if you're a creditor of an estate. But if proper estate planning is done, a lot of times the real estate won't be going through probate either. So, all right, so I got just a couple minutes left. I want to just cover this slide, and then I'm happy to take any questions. Common misconception in West Virginia, though, is creditor missed the creditor claim deadline. We can go ahead and close this estate and distribute the money out to the beneficiaries, and we don't have anything to worry about. They're out of luck. And that is not necessarily the case. So 44-2-27, or if you're in a fiduciary supervisor county, 44-3A-33 says that a creditor can actually still go after the beneficiaries of the estate, or in the case of intestacy, the heirs of the estate, for payment within 2 years after the distribution, as long as they're not otherwise barred by a statute of limitations. Okay, so if your claim's not barred by a statute of limitations, they have 2 years to go. And I always take the position, yeah, the creditor missed their statute of limitations, but if there are assets available to pay, if it's insolvent, that's fine. But if there are assets available to pay, personal representative, you probably ought to take care of it somehow, because we don't want them coming back and knocking on the beneficiary's door for up to 2 years. And I've actually had to use this before. Now, the beneficiaries doesn't mean that they're fully liable for the debt. They're only liable up to the amount they receive from the estate. But that is something that you can, a lot of people think, oh, missed creditor claim deadline, we're done. They're barred. They can never come back against us for the money again. It's not the case. They can still go after the beneficiaries of the estate. It's again, for up to 2 years unless they're otherwise barred. It's a good technique, a good tool to use if you're representing a creditor and they're upset because they didn't get the notice, or they didn't get notice in time to file a timely claim, or for whatever reason they didn't file a timely claim. I can usually tell them, well, as long as it hasn't been too long since the estate is closed, you may not be out of luck. We can still maybe rattle some cages, try to get you paid. So, okay, so I went through a lot of that very quickly. Like I said, it is a topic that gets a lot of attention in West Virginia, because I don't think our statutes are real clear on how to deal with creditor claims. But there are statutes on the books, that statutory framework available to deal with these, especially the insolvent estate type of issue. So happy to answer any questions anybody may have. End of the day. All right, thank you all very much.
Let me just do one more plug for the State Bar Probate Committee, because if you like the Ancillary Administration by Affidavit statute, yesterday the legislature in Senate Bill 635 has put in a new bill, which is Small Estate Administration by Affidavit in West Virginia, that will allow an affidavit process to administer a small estate, which is defined as an estate which has $50,000 or less in personal property and $100,000 or less in probate real estate. So you might want to track that. It's Senate Bill 635.
On behalf of the State Bar, thank you to our presenters. Thank you for participating today. And just a reminder, you're eligible for 3 CLE credits for your participation in the seminar today. An email will be going out for you tomorrow for you to confirm your CLE credits. It will have the 2 different links. Click on the link for attendance credit if you were here today, or if you participated by video conference. Click on the link for online credit if you participated only by phone. If you don't receive that email, be sure to check your spam accounts in case it got sent to that before you call and say, I didn't get that link. So we just wanted to remind you to do that. And again, you won't have to self-report the credits. Those links will be sent to you so you can get the credit. So safe travels to everybody that came. We appreciate it. Thank you. Thank you.